Good morning, everybody. Thank you for joining me for today's webinar. Today, we're going to be talking about planning for a married couple when both spouses are in a nursing home. My name is Amber Hines, and I'm going to be the presenter today. If you're interested in a copy of the slides from today's webinar, feel free to type your email address into the chat function of the GoToWebinar. For whatever reason, I'm unable to upload the handouts into there isn't a handouts portion of the GoToWebinar dashboard. So if you're interested in a copy, just shoot your email address to me and I'd be happy to email those over to you. If you have any questions during today's program, feel free to type those into the questions box as well, and I'd be happy to answer those questions at the end of today's webinar. Again, my name is Amber Hines. I have been working with elder law and estate planning attorneys for the last 15 years on Medicaid compliant annuities, as well as hybrid long-term care insurance policies. I am insurance licensed in all states, and I also hold my Series 65 license with FINRA as well. I created Ashford to assist attorneys and advisors with pre-planning solutions as well as crisis Medicaid solutions. We can help you and your clients by offering complimentary case analysis. So we help you to determine the optimal amount to go into an annuity, the term that the annuity should be structured for, and which assets should be annuitized. For example, if you have clients that have existing retirement accounts or qualified accounts, we can look at using a 60-day rollover or a direct trustee to trustee transfer to convert those assets into accountable resource into a income stream. We offer assistance from the beginning to the end of the case. We provide quotes for the annuity from various insurance companies. We offer assistance with the actual funding of the annuity. And then also we offer assistance with the death claim process. So if you have a client that does purchase an annuity through us and they end up passing away, we will assist with reaching out to the state Medicaid agency to determine if there is a claim, and then also getting the secondary or contingent beneficiaries paid out. We work with A-rated insurance carriers, and we offer top-notch customer service as far as getting back to you the same day in most cases with a proposal and with our suggestions on how annuity should be structured. So today, again, we're going to be talking about situations where both spouses are in a nursing home and both are applying for Medicaid at the same time. In this type of situation, we do not have a well spouse or a community spouse, as most states refer to them as. So both spouses in this situation are going to be referred to as the Medicaid applicant or the institutionalized person. So we're going to have two institutionalized individuals that we are applying for Medicaid at the same time. When we do have this situation where both spouses are in a facility and they are applying for Medicaid, we know that there's going to be income and asset limitations. In this case, just like every other Medicaid planning situation, when we're looking at a income limitation when both spouses are in a facility, we must have each of the spouses' total income less than what the cost of care is. So we would be looking at the cost of care for each spouse. In some situations, one spouse is requiring more care than the other spouse, or one spouse has more income than the other. And so we need to look at each individual cost of care as well as individual incomes to make sure that the total income is less than each of the costs of care. If we are planning in a state that is an income cap state, then we will need to set up a qualified income trust or a Miller trust in order to have the income that is above the $2,300 a month flow into the Miller Trust in order to establish that that client is income eligible for Medicaid. And again, the income limitation is going to apply to each spouse. When we look at the asset limitation for the situation where both spouses are applying for Medicaid, generally each spouse is able to keep $2,000 in assets. This does vary depending on the state that we're in. If you do refer to our website, ashbur.com, you can see that there are asset limitations for each state in the situation where both spouses are applying for Medicaid. For example, a state like Ohio and New Jersey have an asset limitation of $3,000 total between the couple. So in that case, each person would be keeping around $1,500 of assets in their name, whereas a state like Illinois has an asset limitation of $2,000 per spouse or $4,000 total. So we're looking generally at $4,000 or $3,000 as the total amount of liquid assets that a couple can keep between the two spouses when they're both going to apply for Medicaid. It's a very limited amount of assets in comparison to a married couple situation where one spouse is remaining in the community still. When we look at why planning for both spouses needing care being more complicated than traditional community spouse planning, there's a few reasons why planning for both spouses when they're both applying for Medicaid at the same time is a little bit more complicated than traditional community spouse planning. One of the reasons is that we don't have a community spouse that we can transfer most of the assets to and immediately qualify the Medicaid applicant for Medicaid. In a traditional community spouse case where we have one spouse that is in a facility and one spouse that is remaining in the family home or is in the community, we're able to have the community spouse keep around $130,000 of assets. Whereas in this situation, when we do not have a spouse that is remaining in the facility, we're very limited as far as the amount of assets that the spouses can keep. Usually, like we just talked about, it's around $2,000 each or $3,000 total that they are able to keep between the two spouses. Also, if a gift or a transfer is made by one or both spouses, most state Medicaid agencies will split the penalty period equally between the spouses. The planning opportunities that involve an annuity when both spouses are applying for Medicaid eligibility at the same time involves a gift and annuity plan. We're going to look at a married couple scenario with Robert and Mary. Robert is 80 years of age. He has Parkinson's, resides in a nursing home. He has monthly income of $2,000 and his monthly nursing home bill is $10,000 per month. Mary is Robert's wife, who is 75 years of age. She is ill and frail from caring for Robert for many years. She also resides in a nursing home and she has monthly income of $1,000 per month and her monthly nursing home bill is $10,000 per month. The family feels that they each could live for another 5 years in this sort of supportive care environment, and they have around $305,000 of non-IRA bank accounts as far as their liquid assets go. When we look at their individual monthly income shortfalls or their deficits, we see that Robert is spending $10,000 a month on his care. He has monthly income of $2,000. On a monthly basis, he has a shortfall of $8,000 per month from being able to meet his cost of care. Mary is also paying $10,000 per month for her care. She has monthly income of $1,000, and so her shortfall on a monthly basis is $9,000 per month. When we combine their total cost of care and their total monthly income, we see that together they have a monthly income shortfall of $17,000 per month. If the couple does no planning at all and they are depleting their assets by $17,000 per month, they're going to exhaust their entire life savings of $305,000 in just over 1 year or 17 months. Because Robert and Mary's family anticipates them living for many more years, doing nothing at all is not a great option for Robert and Mary. So we're going to look at a gift and annuity plan for this couple. The goals of the gifting plan when both spouses are applying for Medicaid at the same time is to allow a married couple to make an immediate wealth transfer or gift to their intended beneficiaries, and then allow each applicant to qualify for Medicaid at the end of an ineligibility or a penalty period associated to making that gift. I like to refer to the gifting plan in an individual situation or in a married couple situation like this as thinking of it as a bucket method, or the money that the client has going into 3 different buckets. So if we think about trying to spend the Medicaid applicants down to $2,000 or $3,000 or less, then we see that of the $305,000 that the applicants have, they're going to keep around $2,000 each in their name. They're going to also make a gift and put part of the $305,000 into the gifted pot, and then the third pot of money or bucket of money is going to be that each applicant purchases a Medicaid compliant annuity. So they're going to keep some, make a gift with some of the money, and then also purchase an annuity with some of the money. Step 1 in the gifting plan would be to determine the monthly income shortfall. We know that the total cost of care between the 2 spouses is $20,000 per month. They each have, or their total income on a monthly basis is $3,000 per month. So their shortfall is $17,000 per month. Next, we're going to determine the burn rate, or how much money is being used to pay during the shortfall, and also adding that to the divestment penalty divisor. So we're going to add the income shortfall of $17,000 per month to the divestment penalty divisor of $21,672. This is a number based on a state that has a monthly divisor of $10,836 per month for an individual. Since we are doing a gifting plan for each spouse, we're actually doubling that divisor up to the $21,672, and determine that the burn rate on a monthly basis is $38,672. The divisor is a number that Medicaid calculates, or that Medicaid uses to calculate the penalty or ineligibility period for money that is gifted or transferred out of the Medicaid applicant's name. It is supposed to be the average cost of 1 month in a nursing home in your state. So in this state that we are using, that's around $11,000 per month. This is a state that has a higher cost of care than a state like Georgia, where I'm at, where the cost of care is only $6,800 per month. So you can find out what your state Medicaid divisor is by either looking in your state Medicaid manual, or our website also has the divisor numbers for each state as well. The divisor in this case is going to be doubled because we have 2 Medicaid applicants, and Medicaid is going to split or apportion the penalty period equally between each spouse. Most state Medicaid manuals do have language in them that refer to both spouses being in a penalty situation at the same time, and they'll include language talking about splitting the penalty period or dividing the penalty period equally between the two spouses. Next, we're going to determine the penalty period term. We're going to do this by taking the spend down amount of $305,000 and dividing by the burn rate of $38,672. And we determine that the term of the plan is going to be 7.88 months. The gift amount in this case is multiplied, we're multiplying the term of the plan of 8 months by double the divisor of 21,672, and we determined that of the 305,000, the couple is able to make an immediate gift of 173,376. Of the $305,000 that the couple has, when we subtract out the gift amount of 173,000, we determined that the annuity amount is going to be 131,624. The annuity of 131,624 is the total amount that we have available to purchase two separate annuities, one for Robert and one for Mary. We need to determine how much of the 131 is going to go into an annuity for Robert versus for Mary, and we need to do that based on what their individual monthly income shortfalls are. We're not able to do a jointly owned Medicaid compliant annuity in most situations based on the insurance company and their limitations on how they can structure the annuities. So we would be setting up two separate individual annuities, one for Robert and one for Mary. If you recall, Robert had an income shortfall of $8,000 per month. Mary had a monthly income shortfall of $9,000 per month. So we know in this case that we're able to take the 131,000 and structure a little bit more money going into the annuity for Mary than for Robert because she has more of an income shortfall than Robert does. Of the 131,000 that we have available to purchase the annuities for, we put 62,000 into an annuity for Robert. This is structured over an 8-month time frame. This is matching the penalty period or the ineligibility period that we determined earlier in the plan. And we see that the monthly payout on the annuity is going to be $7,760 each month. The total payout is $62,080. That $80 is just representing the interest that would be paid on the annuity contract over that 8-month time frame. And then Mary is going to be purchasing an annuity for $69,624, also over an 8-month time frame, and her monthly payout is going to be $8,710 per month. This is greater than what Robert's income is from the annuity based on her having a greater income shortfall than Robert does. The total payout on her annuity is $69,680. And you'll notice that an annuity can only be structured for a whole number of months, which is why we did the annuity in this case for an 8-month time frame versus doing an annuity for 7.88 months. We're not able to do a fractional time frame on the annuity. If we were able to do that, then the annuity wouldn't make equal payments, which is one of the requirements of an annuity to meet the Medicaid qualification criteria. During the 8-month penalty period, Robert will have total monthly income of $9,760 per month. We determined this by taking Robert's Social Security income of $2,000 and adding his annuity income that we just talked about at $7,760 each month. During the penalty period, Robert's monthly income shortfall is going to be $240 per month. This is determined by subtracting Robert's total income from the annuity and Social Security at $9,760 from his cost of care at $10,000 per month, and he has a shortfall each month of $240. During the penalty period, Mary's total income is going to equal $9,710 per month. And this is determined by adding Mary's Social Security income of $1,000 to her annuity income at $8,710. And we determined that her total income is the $9,710. During the penalty period, Mary's shortfall is going to be $290. This is determined by subtracting her Social Security and annuity income at $9,710 from her cost of care, also at $10,000 per month. We determined that she has a shortfall of $290 each month. Many people ask the question why there has to be a monthly income shortfall and why we can't create exactly the amount of income that a Medicaid applicant needs by way of the annuity. And it really is based on establishing that the client is otherwise eligible for Medicaid, or that their income is less than their cost of care and they have been spent down to the allowable limits. If we are creating exactly the amount of income that is necessary from the annuity to meet the cost of care, then we're not establishing that there is an income need. So in that case, the penalty period or ineligibility period is not going to start under Medicaid or under the otherwise eligible criteria. And so we always have to build in a monthly income shortfall between the client's total income and what their cost of care is. The economic results of Robert and Mary's plan was that we were able to make an immediate wealth transfer or a gift of $173,000. Robert and Mary were each ineligible for Medicaid for an 8-month time frame, which is the private pay or penalty period. This was also the time frame that we structured the annuities for as well. Robert had total monthly income of $9,760 during the 8-month penalty. And we talked about that Robert's monthly income shortfall was $240 per month. And he's going to be eligible for Medicaid in month 9 after the penalty period is over. Mary, during the ineligibility period, she has monthly income of $9,710. Her monthly income shortfall was $290 per month, and she also is going to be eligible for Medicaid in month 9. The advantages of the gift and annuity strategy was that the family was able to make an immediate wealth transfer or a gift of $173,000, which is more than 50% of the total assets of $305,000. And Medicaid is going to start paying for Robert and Mary for both of their care in month 9 after the penalty period is over. The disadvantages of the gift and annuity strategy is if Robert and Mary do not live through the 8-month private pay period, then they're not experiencing any kind of economic benefit from Medicaid, because Medicaid is not going to start paying for their care until month 9. So we always want to consider the life expectancy of both spouses when we're doing a gift and annuity strategy, because if they don't live during that full penalty period, then we're not actually gaining Medicaid eligibility until that time frame is over with. The annuity parties, as far as Robert's annuity is concerned, he is going to be the annuity owner, the annuitant, and the payee. The state Medicaid agency would be the primary beneficiary to the extent that they would provide Medicaid benefits on behalf of Robert. The contingent or secondary beneficiary could be whoever Robert chooses to name. This could be children, a trust, a charity, or whoever he would like to benefit from the annuity policy. Mary's annuity is going to be set up the exact same way, where Mary is going to be the annuity owner, the annuitant, and the payee. The state Medicaid agency would be the primary beneficiary for the amount that they provided on behalf of Mary. And again, she can name whoever she chooses to as a contingent or secondary beneficiary. She can name children, a trust, a charity, or whoever she wishes. If we assume that Robert passes away 6 months after the annuity is purchased, what happens to the annuity contract, since it was established for an 8-month time frame? With the state Medicaid agency being listed as the primary beneficiary to the extent that Medicaid benefits are provided, Medicaid was not actually providing care during that time frame. So we would be obtaining a clearance letter from the state Medicaid agency indicating that they did not provide any Medicaid benefits to Robert during that 6-month time frame. And assuming Robert lists his children as a secondary or contingent beneficiary, then their children would be entitled to receive the remaining annuity amount. One thing to keep in mind is that there are some states that will add the remaining 2 months of Robert's penalty period to Mary's penalty period. So in that case, if the state were to add the 2 months of Robert's penalty to Mary's, then the money that is remaining in Robert's annuity may need to be used to pay for 2 additional penalty months for Mary. If Robert predeceases the 8-month time frame, Mary's initial penalty period was 8 months. It could be extended for an additional 2 months that Robert did not survive, which would result in a 10-month penalty period. And with Mary's annuity only being structured with an 8-month time frame, the additional 2 months would likely need to come from the money that is remaining in Robert's annuity, or it would be money that would come from the $173,000 that was gifted to the couple's children or to the giftees. If we assume that Robert passes away 12 months after the annuity is purchased, absolutely nothing would happen to the annuity in this case, because Robert's annuity was structured for an 8-month time frame, and it's only going to pay out for an 8-month period certain or 8-month time frame. If Robert were to pass away in month 12, there's not going to be any impact on the annuity because it's already done paying out after the 8-month time frame. The time frame to implement the gift-in annuity plan when both spouses are applying for Medicaid at the same time would be to make the gift, purchase both annuities, one for each spouse, and then apply for Medicaid. This generally is going to all take place in the same month. When the Medicaid application is made, we are then able to obtain the penalty period determination from the Medicaid office. In this case, Medicaid would determine that the penalty period is an 8-month time frame based on the total gift of $173,000. We would use the annuity payments to pay the nursing home during the 8-month penalty period. And then finally, after that penalty period is over, after the 8 months, then Medicaid is going to start paying for the couple's care based on them being outside of the 8-month private pay or penalty period. How does the plan change if the applicants reside in an income cap state? If you are in a state that is considered to be an income cap state, then we know right now that the monthly income cap amount is right around $23.80 per month. In this case, we were creating total monthly income for each spouse, for Robert and for Mary, that was over $9,000 per month. So we know that the total income is greater than the income cap amount at $23.82. In this case, a qualified income trust or a Miller trust would need to be set up so that the income from the annuity and Social Security could flow through that trust before paying for the nursing home, and that would be necessary during the 8-month annuity time frame. In most cases, the annuity is set up so that it is just going to directly deposit the payments from the annuity directly into the qualified income trust so that the clients don't have any issue with meeting that income cap amount as far as the annuity already being direct deposited into directly into the Miller trust. If you're unsure whether your state is an income cap state, all of the states that you're seeing on the screen that are in orange are considered to be income cap states that you would have to do additional planning for your clients if their income is exceeding the $23.82 on a monthly basis. A couple of alternatives to planning alternatives to the gift and annuity strategy would be doing a gift and promissory note strategy. So instead of setting up 2 separate annuity contracts, clients could make a gift and then they could also set up 2 separate promissory notes that are going to make payments back to the Medicaid applicants during that ineligibility period. And then another alternative, if your state allows for it, would be to do a gift and return or a gift and partial cure. Some states allow for the promissory note and some states don't. Likewise, some states allow for the gift and return strategy and some states do not. So you'd want to make sure that your state does recognize one of these planning strategies before implementing the gift and note or gift and return strategy for your clients. A fact change would be considering the timing of each spouse needing care. There are situations where we have clients that are currently on Medicaid and then the spouse that was healthy, the community spouse, ends up needing care and they go into a nursing home and need to apply for Medicaid. So if we consider a situation where one spouse is already on Medicaid and then the second spouse goes into a facility and they apply for Medicaid, some states are only going to apply the penalty period to the second spouse if the second spouse were to make a gift. And so that's going to be more like your traditional gift and annuity strategy where it's just one spouse that would be purchasing the Medicaid compliant annuity to pay through a penalty period that applies to the second spouse that would go into the facility. They're going to keep the first spouse on Medicaid and there's not going to be any interruption to their Medicaid benefits. But other states are going to apply the penalty period to both spouses, which is the situation that we were talking about today. So in this second situation, if your state does apply the penalty period to the spouse that was on Medicaid along with the second spouse that enters the facility, then you would be doing two separate annuities because the first spouse is going to come off of Medicaid and need to privately pay for the penalty period. You'll want to look in your Medicaid manual to determine whether your state does share in the, or does assess the penalty period to each spouse that would be applying for benefits. I did include some language here. This is from Michigan's Medicaid manual that talks about sharing in a penalty period between two spouses. So your state may have language that addresses situations where one spouse is already on Medicaid and then a second spouse would end up needing to apply for Medicaid at a later date. In summary, the timing of the plan is going to be everything. So we need to determine if both spouses are applying for Medicaid at the same time, or if one spouse is already on Medicaid. This is going to determine whether we do a gifting plan for only one spouse, or if it's going to be a situation where both spouses are sharing in a penalty period. And so we would set up an annuity or a note or the return for each spouse. And then also we want to always consider the couple's longevity. If one spouse does predecease the penalty period or the annuity term, then the resulting penalty period may be added to the surviving spouse's penalty. And I will look to see now if anybody has questions for me. Again, if you're interested in the handouts from today's program, feel free to shoot me an email or type your email into the questions portion of the GoToWebinar dashboard. My email address is up on the screen now. It's amber@ashbur.com. Otherwise, you can call me as well. And it does look like we do. Okay. Could you quickly review how you determined the amount that went into each annuity and how it was split? Yes. So I'll go back to So after we determined that the gift amount in this case was $173,000, I subtracted that from the spend down amount of, or the total accountable resources of $305,000, and determined that the annuity amount is going to be $131,624. And of the $131,000, we know that Mary has a greater income need than what Robert does because she only has monthly income of $1,000 per month, whereas Robert has income of $2,000 per month. Her shortfall is greater at $9,000 per month. And so when I'm looking at how much can go into an annuity for each spouse, it's really just kind of a guess and check type of calculation that I do. I know when I add the $62,000 that's going to go into Robert's annuity to Mary's annuity amount of $69,624, those two numbers add up to the $131,000. And I also know that I cannot be creating more income for Robert than $8,000 per month. And for Mary, I can't create more than $9,000 per month. So it really just is working into the numbers backwards. First, for Robert, I know that I can't create more than $8,000 a month in income for him by way of the annuity. So I work into that to say that he needs to put $62,000 into his annuity, and then whatever is left after his annuity is purchased is the amount that Mary is going to purchase her annuity for at the $69,624. But when you add up those two numbers, that is the $131,000 that I had calculated on the previous slide. But it's really just kind of a numbers game as far as how much needs to go into each annuity for each spouse, making sure that we're keeping their total income below what their shortfall is on a monthly basis. Okay, and then I think the majority of, oh, there's another question. Do you always round up if there's a penalty of say 8.8 months? Would the annuity then be for 9 months and not 8 months? It really depends on the situation, but typically if the resulting penalty period is above 0.5 months, then yes, I would be rounding the penalty period up to a 9-month time frame, and I would be doing a 9-month annuity. Whereas if the resulting penalty period would have been like 8.1 months, then I would work into the numbers backwards and do a slightly greater gift amount and penalty at, let's just say 8.25 months, and then I would set up an 8-month annuity. You generally don't want a penalty period that's going to be like 8.05 months and then a 9-month annuity, because you're just going to pay that income to the nursing home in that extra month of penalty. So you're correct that if I would have had a penalty of 8.8 months, I would have done a 9-month annuity. And that goes back to the situation of we can only set up an annuity for a whole number of months. It would have to be an 8-month annuity or a 9-month annuity. We can't do a fractional time frame for the annuity periods are in. Okay, then I think the majority of these other comments and questions are related to getting copies of slides and being able to sell these annuities. So I will respond to each of your questions through email. But again, I want to thank everybody for joining me today. And if you have any other questions that come up, feel free to call or email those questions. And I look forward to next month's webinar. And take care, everybody. Thank you.